The Epstein files. They exist, or maybe they don't. It's a cover-up. It's a witch hunt. It's a hoax, or maybe the whole thing is a big old nothing burger. Maybe the Epstein files are really the friends we made along the way. Actually, they're probably the friends we lost, because a very long time ago, Trump and deceased pedophile Jeffrey Epstein were pretty good friends. And a very short time ago, Trump and Rupert Murdoch, the owner of the giant conservative media empire, were pretty good friends too. But now that's all over, and there's nothing to see here. Move along, please.
I don't understand it. Why they would be so interested. He's dead for a long time. He was never a big factor in terms of life. I don't understand what the interest or what the fascination is.
Which is why the president filed a lawsuit against Murdoch and the Wall Street Journal, which the media mogul also owns, because the paper got a copy of a birthday card Trump sent to Epstein decades ago and published a story about it. And obviously, nothing will put this thing to bed like protracted litigation on the public docket. Did the guy who spent his entire life suing and being sued by everyone he ever interacted with forget that discovery is real? Okay, drink up. Let's do this. On July 17th, the Wall Street Journal published a story entitled "Jeffrey Epstein's Friends Sent Him Bawdy Letters for a 50th Birthday Album." One was from Donald Trump. Journalists Khadija Safdar and Joe Palazzolo reported that in 2003, 3 years before the notorious pedophile's first arrest, his girlfriend, Ghislaine Maxwell, assembled a leather-bound album of personal messages for his 50th birthday. What else do you get for the pervert who has everything, right? Many of the messages were a little off-color. See above. The billionaire Les Wexner, founder of mall staples like Victoria's Secret, wrote, "I wanted to get you what you want, so here it is," with a drawing of breasts. A former assistant wrote, "Jeffrey, oh Jeffrey, everyone loves you. Fun in the sun, fun just for fun. Remember, don't forget me soon. Epstein, you rock. You are the best," which is embarrassing enough to make Wexner's boobs seem like poetry. Trump's contribution is described as an outline of a naked woman, hand-drawn with a heavy marker. A pair of small arcs denotes the woman's breasts, and the future president's signature is a squiggly Donald below her waist, mimicking pubic hair. Inside the figure was a typewritten note imagining a conversation between Trump and Epstein. Voiceover: "There must be more to life than having everything." Donald: "Yes, there is, but I won't tell you what it is." Jeffrey: "Nor will I, since I also know what it is." Donald: "We have certain things in common, Jeffrey." Jeffrey: "Yes, we do, come to think of it." Donald: "Enigmas never age. Have you noticed that?" Jeffrey: "As a matter of fact, it was clear to me the last time I saw you." Donald: "A pal is a wonderful thing. Happy birthday, and may every day be another wonderful secret." The president vehemently denies that he had anything to do with the album. He said, "This is not me. This is a fake thing. It's a fake Wall Street Journal story." And he protested that he doesn't draw dirty pictures. "I never wrote a picture in my life. I don't draw pictures of women. It's not my language. It's not my words." But as the New York Times and Washington Post were quick to point out, Trump has contributed numerous line drawings to charity auctions over the years, often using his unmistakable echocardiogram signature as part of the image. Trump threatened to sue the Wall Street Journal just like I sued everyone else. And on Truth Social, he held that it was a fake letter and he was going to sue Rupert Murdoch's ass off and that of his third-rate newspaper. Also, he doesn't draw pictures. Thank you for your attention to this matter, DJT. I mean, we've all seen him take a Sharpie to enhance the anatomy of a hurricane. But the weird thing here is how unsurprising this story is. The president's friendship with Epstein in the late 90s and early 2000s wasn't exactly a secret. We've all seen the video of them ogling women on the dance floor at Mar-a-Lago and photographed together at parties. CNN just unearthed photos of Epstein at Trump's wedding to Marla Maples in 1993, and it's not exactly news that the president can be vulgar. Trump's locker room talk didn't prevent him from getting elected twice.
And when you're a star, they let you do it. You can do anything.
Whatever you want.
Grab them by the pussy.
But Trump wasn't just yelling at clouds when he threatened to sue Rupert Murdoch. And if you're shocked that Trump would turn against the billionaire who owns the right-wing media empire that ascended him to power, you haven't been paying close enough attention. Trump is the most anti-First Amendment president in the modern era and will go after anyone who publishes anything he doesn't like. That's why I want to take a moment to thank today's sponsor, Incogni, for being a longtime supporter of not just this channel, but independent journalism at large. Whether you're a journalist active on social media or just tired of all those robocalls blowing up your phone, Incogni is a great way to take back control of your private, personal information. Incogni removes your personal data from online data brokers by searching the internet, reaching out directly on your behalf, and forcing them to take down your personal info. If the data brokers resist, Incogni will take care of that too, because Incogni fights back. Those data brokers are why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting all those spam calls lately or even had your identity stolen. So if online privacy is important to you, give Incogni a try. If you click on the link on screen or down below, you can try Incogni risk-free for 30 days with a 60% off discount and get a full refund if you're not into it. And if you keep it, you'll still get the exclusive 60% discount so long as you used our link or the code LegalEagle, all one word. So sign up for Incogni or we will see you in court. The very next day after Trump threatened to sue Rupert Murdoch, he made good on his promise and filed suit against the Journal, the paper's holding company, News Corp CEO Rob Thompson, Murdoch, and the reporters Khadija Safdar and Joe Palazzolo. He alleged defamation as well as defamation per se. Defamation is a tort which involves a false statement of fact about the plaintiff published to a third party. The speaker has to have known the statement was false or at least been negligent as to the veracity of the statement, and the plaintiff has to show that he was actually harmed. So the four elements of defamation are falsity, publication, negligence, and damages. Defamation per se is slightly different. It involves a defamatory statement so inherently scandalous and horrible that damages are presumed and you don't have to prove them. 100 years ago when I went to law school, it was reserved for suggestions that women were unchaste or that the plaintiff suffered from so-called loathsome disease, by which they meant syphilis. Today, it's more commonly associated with serious crimes or conduct incompatible with your profession. So if you're a priest and someone accuses you of owning a brothel, that might be defamation per se. Now, if you're a public figure, proving defamation is substantially more difficult thanks to the 1964 Supreme Court case, New York Times v. Sullivan. To establish defamation, public figures have to meet what's known as the actual malice standard, proving that the speaker knew or was reckless as to the truth or falsity of the statements. Donald Trump is obviously a public figure, so he'll have to meet this heightened standard to prove defamation. And that is more or less the sum total of the law you'll need to know to evaluate this complaint. So let's take a look. The first page describes the nature of the action. So Trump accuses the Wall Street Journal of failing to live up to the paper's motto of having editorial standards that don't waver. And the second page is more of the same. He says the article was an attempt to inextricably link President Trump to Epstein, concocted to malign his character and integrity. And then there's a bunch of blah, 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 none of which is the law part. Next, the complaint describes the parties. And then there's a section on jurisdiction, which is basically why does a federal court have the legal right to hear this case? In this instance, it's because President Florida man and the defendants are from two different states. That's called diversity of jurisdiction. And then there's venue, which is why is this particular federal court the right place for this lawsuit? Put a pin in that last one. I want to come back to it. So all of that is what you will see in every single federal complaint. Then you get to a statement of facts where Trump has to say exactly which statements from the article he says are defamatory. Here's the stuff he says is defamatory per se. The description of the, quote, body image, the statement that it isn't clear how the letter with Trump's signature was prepared, and the enigma's never aged dialogue. Remember, for a statement to be defamation per se, it has to be more than just untrue. It has to be so inherently awful that the plaintiff doesn't even have to prove that he was harmed. Trump is claiming that it's defamation per se to suggest that he drew a picture of breasts in 2003 and wished Epstein happy birthday with a grody poem. This is a guy who posed on the cover of Playboy magazine. He appeared in a softcore porn film. He autographed women's breasts on the campaign trail with a giant Sharpie, of course. And still he claims that it's defamation per se to claim that he drew boobies 22 years ago. I mean, it's a bold strategy, Cotton. Let's see if it pays off. Here are the statements that Trump claims are implicitly defamatory. There's the title, Jeffrey Epstein's friends sent him bawdy letters for a 50th birthday album. One was from Donald Trump. And several paragraphs that call Trump Epstein's friend or pal or say the two socialized together. But they did socialize together. Trump even gave a quote to New York Magazine in 2002 saying, "I've known Jeff for 15 years. Terrific guy. He's a lot of fun to be with. It is even said that he likes beautiful women as much as I do, and many of them are on the younger side. No doubt about it, Jeffrey enjoys his social life." Oh. And since truth is an absolute defense to defamation, I'm not sure where this thing is going. And then there's the little problem that Trump is a public figure, so he'll have to meet the actual malice standard. He'll have to prove that the reporters knew the story was false, or at least that they were reckless, and they ran with it anyway, which is a heavy lift. You can't just say it was false and they knew it, give me money now. And nowhere in this complaint are any specific factual allegations that would show the reporters knew the story was false. Trump just states in what's known as a conclusory fashion that the reporters concocted this story to malign his character integrity and that the supposed letter is a fake and the defendants knew it when they chose to deliberately defame President Trump. That's probably not going to do it, nor is simply reciting the elements of the tort and saying, yes, that, they did all that. And you know what else won't do it? Saying the reporters knew it was false because I told them so before they published. You almost certainly cannot establish actual malice by saying, my lawyer sent an email to defendants advising that the intended article was false, or Murdoch and Thompson authorized the publication of the article after President Trump put them both on notice that the letter was fake and non-existent. And that trick definitely will not work when you're the guy who denied that he sexually assaulted advice columnist E. Jean Carroll, only to have a jury award her $83 million for defamation, and also a convicted felon, and not for nothing, but Trump also denied that he'd paid $130,000 in hush money to adult film star Stormy Daniels in 2016. And oh look, there's Joe Palazzolo with the whole crew from the Journal collecting their Pulitzer Prize for breaking that Stormy Daniels story. Okay, so the rest of this complaint is mostly screenshots of social media posts about the article. The point of all that is to establish that the story went viral and thus really damaged the president, which is to justify the ginormous damages they're seeking. Here on the last page is what's known as the ad damnum clause, $10 billion. That's what they want. How did they arrive at that number? No one knows, but that's what he says he's owed. There's one thing that Trump is 100% right about, though, and that is that he absolutely has sued everybody else. This is not the president's first courtroom rodeo. Here is a non-exhaustive list of people and organizations Donald Trump has sued. He sued the New York Times for reporting that Trump and his siblings depleted their father's estate to avoid a massive tax bill. That wound up costing him $400,000 to pay the paper's legal fees. He sued the Washington Post for an article about the Mueller investigation. That got dismissed too. He sued Hillary Clinton, James Comey, and half of Washington, D.C. for doing the RICO to him in the 2016 election. That one got him $1 million in sanctions from Judge Donald Middlebrooks, who accused him of deliberate use of a frivolous lawsuit for an improper purpose and engaging in a pattern of bad faith litigation filed to advance political ends and unmoored from any actual law. He sued CNN and Google and New York Attorney General Letitia James and the Des Moines Register and the Pulitzer Prize Board for defamatory refusal to retract prizes for the Times and the Post. And none of these lawsuits went anywhere in court. In fact, his copyright suit against journalist Bob Woodward and the publisher Simon & Schuster got dismissed the same day the Journal suit was filed. Trump has had some success, though, arm-twisting settlements out of CBS and Facebook, since both companies have pending disputes before the federal government. Also, Twitter paid Trump $10 million to make his troll suit against that company disappear back when Donald and Elon were still pals. Ah, memories. But everything in the Trump era has a weird echo, and so does this newest lawsuit. So you remember that story Palazzolo broke about the Stormy Daniels hush money payoff? Michael Cohen, Trump's longtime personal lawyer and fixer, was the one who negotiated that deal and fronted the cash. The cover-up of the payments is what led to Trump's 34 felony convictions in New York before the election. Cohen eventually turned on Trump, and in 2023, Trump sued Cohen for saying all kinds of mean stuff about him on his podcast. That case was filed in the Southern District of Florida in the Miami division, and you remember, like 10 minutes ago when I said, hey, let's come back to the issue of jurisdiction and venue? We're back. Donald Trump is a Florida resident. He is entitled to file lawsuits in federal court in Florida, but he lives in Palm Beach, and he did not sue Michael Cohen in the Palm Beach division. I think it's safe to assume that he didn't want to risk ending up back in front of Judge Middlebrooks, who sits in Palm Beach and had just sanctioned him. So instead, Trump sued Cohen in Miami, and courts will sometimes boot you for suing in the wrong venue. When Trump's former national security advisor Michael Flynn tried to sue the January 6th committee, he filed in Fort Myers, Florida, but the court immediately transferred the case to the Tampa division, since that's where Flynn actually lived. Because you're not really supposed to be able to, pick your courtroom by filing in the division you think looks best for you. Flynn lost that case, by the way, but do not worry, because if there's one person in America who files more lawsuits than Donald Trump, it is Michael Flynn. The point here, though, is that Trump wasn't really entitled to sue in the Miami division because he didn't live there. He had no venue in Miami. And arguably, the court in Miami didn't have jurisdiction over Cohen because Cohen lived in New York. So Trump solved both of those problems by saying that Michael Cohen's book and podcast were available in Miami, so the federal court in Miami had personal jurisdiction over Cohen. And that's the same argument that he's making in the Wall Street Journal case. Trump says that you can buy and read the Journal in Miami, so he's entitled to litigate this case in Miami instead of Palm Beach. We will see whether the Journal tries to get this case moved, but back in 2023, Michael Cohen did not try to get the case transferred to Palm Beach or even to New York, where he lives. He was perfectly content to litigate in Miami in front of Judge Darren Gales, and after several months of back and forth with Trump scheduling and rescheduling and refusing to show up for his deposition, Judge Gales lost patience and ordered Trump to show up and go under oath on October 9th or get out. And hey, wouldn't you know, on October 5th, Trump's lawyer Alejandro Brito filed a notice of voluntary dismissal because when push came to shove, Trump backed out rather than be deposed under oath. Trump characterized this as a pause and vowed to sue Cohen again at a later date, but of course, he never did. And by now, I think we all know where this is going, because the lawsuit against the Wall Street Journal was randomly assigned to Judge Darren Gales, an Obama appointee, and because there are only so many lawyers in Trump land, Alejandro Brito is back for this episode too. What are the odds that this case makes it through discovery and Trump agrees to answer questions under oath about his relationship with Jeffrey Epstein? So if this lawsuit is likely going nowhere, what is the point of this exercise? Well, if you watched Devin's video on the Epstein files, you know that the administration is trying desperately to get away from the issue of Trump's connection to Epstein.
Are people still talking about this guy, this creep? That is unbelievable.
She says, I gave you all the credible information. And remember, don't let them forget, it's so important, Obama cheated on the election. It's sort of a witch hunt, just a continuation of the witch hunt.
Deputy Attorney General Todd Blanche says he's going to go interview Ghislaine Maxwell in jail. The Justice Department asked the court to unseal grand jury transcripts from her prosecution and the second Epstein case. And Alan Dershowitz, the famed Harvard lawyer who negotiated Epstein's first plea deal, took to the opinion pages of course, the Wall Street Journal to insist that there is no Epstein client list, but if there is, it definitely does not include any current office holders, which sounds real lawyerly and specific, but Dershowitz, who also contributed to the Happy Birthday Epstein album, loves to get real specific.
I kept my underwear on during the massage. I don't like massages particularly.
I've had sex with one woman since the day I met Jeffrey Epstein. My perfect sex life.
Well, okay then. But according to the Journal, the call is coming from inside the Justice Department's own house. Pages from the leather-bound album assembled before Epstein was arrested in 2006 are among the documents examined by the Justice Department officials who investigated Epstein and Maxwell years ago. So if these documents exist, the DOJ has got them, and unsealing those grand jury transcripts isn't going to kick them loose. And by the way, unsealing grand jury transcripts requires permission from the court. And since this testimony likely implicates minor victims of sex crimes, it's pretty unlikely that we're going to see that stuff soon, if ever. It's not clear what's going to happen next in the Wall Street Journal case. The paper put out a statement saying, "We have full confidence in the rigor and accuracy of our reporting and will vigorously defend against any lawsuit." But in the meantime, the Journal joins the Associated Press in being disinvited from certain White House press events. The AP's crime was refusing to say Gulf of America, and White House spokeswoman Caroline Leavitt made clear that the White House is also retaliating against the Journal for First Amendment protected speech. And over on Capitol Hill, Republican House Speaker Mike Johnson just adjourned Congress early to avoid the prospect of a vote to call for the release of the Epstein files. Wow, between that and the lawsuit, that will definitely put this issue to bed.
Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values values that I talk about on this channel: transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team. Okay, that's it. I am not covering any more Trump news, no more Trump legal issues. I'm done. Nope. Even though this lawsuit has the potential to destroy the entire Trump organization, I'm not gonna do it. But I know someone who can. Get me Spencer the Scowl Owl.
Devin, I just want to say thank you for letting me talk about a subject not a single soul is tired of hearing about, and that is Donald Trump's legal problems. Now, of course, asking a criminal prosecutor to talk about civil law is a bit like asking a baseball player to opine about golf. After all, we both use sticks to hit balls a certain distance depending on the circumstances. So without further ado, let's get to it. New York Attorney General Letitia James has filed a civil enforcement action against Donald Trump, Don Jr., Eric Trump, Ivanka Trump, the Trump Organization, and other Trump Organization officers. Better luck next time, Tiffany. It's been a busy summer for America's favorite ex-president. His ex-wife died and was buried on his golf course. Georgia prosecutors impaneled a grand jury to consider charges against him for election tampering. The Department of Justice executed a search warrant to get back documents Trump was storing in his Florida basement. Trump Organization CFO Alan Weisselberg pleaded guilty to 15 counts of tax fraud, and the Trump Organization will go on trial next month. In fact, there are so many legal problems swirling around the former president that LegalEagle has had to open a special Trump unit just to monitor them all. Today, we'll explore the legal basis for the New York State civil enforcement action against Trump. And while the New York Attorney General case is a civil matter, the case rests on Trump and the rest violating criminal laws. What's more, the members of the Trump Organization have invoked their Fifth Amendment right against self-incrimination in a related criminal prosecution. All of that brings this case into my arena. But more on that later. First, we need to start with quite a bit of background. The complaint alleges that for a decade, Donald Trump and the Trump Organization knowingly and intentionally created more than 200 false and misleading valuations of assets on his annual statements of financial condition in order to defraud financial institutions. During the investigation, Mazars, Trump's longtime accounting firm, cut ties with the Trump Organization. In February of 2020, Mazars announced that his financial statements it prepared between 2010 and 2021 could no longer be relied upon. The withdrawn statements formed the backbone of the state's lawsuit. The complaint alleges that Donald Trump and other defendants engaged in conduct meant to mislead Mazars in connection with its work compiling the statements. Because Mazars was not conducting any review or audit procedures, but rather was issuing a compilation in which Mr. Trump's and the trustees' assertions were being compiled into financial statement format, many of the fraudulent statements and strategies remained concealed from or undetected by Mazars. The Attorney General contends that the Trump Organization committed fraud for at least a decade involving conduct across more than 23 different properties and other assets. When valuing Trump properties, the company would change methodology on how to value properties from year to year or even within the same year. Some of the fraud was allegedly accomplished through sophisticated accounting sleight of hand, but other acts were apparently blatant and easy to detect. For example, Trump estimated that his own triplex apartment in Trump Tower was 30,000 square feet, when it was actually about 11,000 square feet.
I always call it massive. Sometimes they say huge.
In 2015, Trump valued that apartment at $327 million in total, or about $29,738 per square foot. Now that price is absurd, since at that point only one apartment in New York City had ever sold for $100 million or more. And that sale was a newly built, ultra-tall tower. No apartment in the 30-year-old Trump Tower was ever sold for more than $16.5 million. Between 2011 and 2015, the value of the triplex incorporated into the statements of financial condition increased more than 400%, from $80 million to $327 million. The bulk of this fraudulently inflated value came from the misrepresentation that the apartment was 30,000 square feet. A property appraiser visited the penthouse in 2010 as part of the underwriting process for an insurance policy. He noted that his visit to the triplex was a bit unusual. This was a unique appraisal appointment. Before the site visit, I was told there would be only 15 minutes to see the apartment. Mr. Trump was home at the time of the appraisal and wanted to do the walkthrough himself. I was unable to see the master bedroom and Mrs. Trump's dressing room per request of Mr. Trump. Mrs. Trump was sleeping. Although I was able to spend slightly longer than the 15 minutes in the house, the appointment was conducted at a speed directed by Mr. Trump, and there was not ample time to take measurements while on site. Only after Forbes published an article in May 2017 entitled "Donald Trump Has Been Lying About the Size of His Penthouse" did the Trump Organization stop inflating the square footage for the apartment. The complaint is over 300 pages and contains numerous examples of Trump allegedly using various deceptive schemes in valuing his golf clubs to inflate their values. And I'm not talking about the values of the actual clubs, but of the clubs where golf takes place. The statements do not list separate values for each of the club's facilities. Instead, the values for those properties are lumped together into a single figure. This was done intentionally to conceal significant swings in the value attributed to individual clubs and to conceal the methods used to arrive at those values. For example, the Office of the Attorney General claims that Mar-a-Lago was valued as high as $739 million, based on the false premise that it was unrestricted property and could be developed and sold for residential use, even though Trump himself signed deeds donating his residential development rights, sharply restricting changes to the property and limiting the permissible use of the property to a social club. In reality, the club generated annual revenues of less than $25 million and should have been valued at closer to $75 million. And this is what brings us to the New York Attorney General's civil enforcement action. The New York Office of the Attorney General filed a civil complaint alleging 7 causes of action against Trump and his co-defendants for violating New York's executive law. The state is seeking dramatic remedies, including the disgorgement of $250 million in Trump Organization profits, the cancellation of business certificates for Trump's corporate entities, and a 5-year ban on Trump and his company from entering into any New York commercial real estate transactions. Tish James also wants to ban Trump and his associates from applying for loans from any New York entity and to stop them from serving as an officer or director of a New York corporation. This would effectively destroy the Trump Organization. All 7 causes of action are brought under New York Executive Law Section 63 Sub 12. This law authorizes the New York Attorney General to bring civil lawsuits to enjoin repeated fraudulent or illegal acts or persistent fraud or illegality in the carrying on, conducting, or transaction of business. The law is a broad discovery tool for prosecutors who only need to show a capacity or tendency to deceive in order to issue subpoenas before a complaint is even filed. Civil penalties include actual damages, disgorgement of profits, canceling of corporate certificates, and other prohibitions that would effectively kill the Trump Organization's ability to do business in New York. Trump is no stranger to New York's executive law. The New York Attorney General's office used it to sue Trump University for fraud in 2013. In that case, the trial court ruled that Section 63 Sub 12 did not give the Attorney General the ability to pursue fraud claims only under the executive law without proving that Trump University violated state fraud statutes. However, the appellate division reversed that trial court ruling, holding that the Attorney General could use Section 63 Sub 12 as a catch-all anti-fraud statute. After the decision, Trump settled the case. So thanks to the Trump University case, the Attorney General now has an easier route for proving the Trump Organization committed fraud. To prove a violation of Section 63 sub 12, the state only has to show a pattern of fraudulent or illegal business actions. The term fraudulent or deceptive practices generally includes acts which may be characterized as dishonest and misleading. The terms are not limited to instances of intentional fraud in the traditional sense. Now, just to be clear, James is not criminally prosecuting Trump and the Trump Organization for tax fraud. James said she has evidence that Trump and his family and corporate officers committed crimes, and she referred those potential cases to the IRS and to the Manhattan District Attorney, Alvin Bragg. But at this point, all we're talking about is a civil case. The Attorney General says investigators uncovered over 200 false and misleading valuations of assets for the 11 statements covering 2011 through 2021. Most large corporations use outside accountants to compile their financial statements. The Attorney General says that Trump rarely hired outside professionals to prepare any of the asset valuations for the statements. On the rare occasion that the organization did get outside advice on how to value the assets, the Trumps routinely ignored or contradicted their advice. For example, an outside appraiser said the homes Trump could build on his Aberdeen, Scotland golf course would result in a net present value profit of 16 to 19 million euros, the equivalent of about 18 to 21.5 million dollars. The Trump Organization allegedly ignored that valuation and instead valued the land at more than 300 million in Trump's financial statements. The complaint alleges that Trump and his partners and children committed persistent acts of fraud, and that all of this occurred in an atmosphere conducive to fraud in which the goal of increasing Mr. Trump's reported net worth on the statements was well known and carried out by his agents and subordinates. All that conduct was directed toward presenting misleading statements to others, including lenders, insurance companies, and governmental entities. The acts of fraud alleged here were repeated, entailing, among other things, dozens of specific numerical entries in financial spreadsheets, dozens of verbal representations in financial statements, and other fraudulent and misleading conduct by the defendants. The state argues that this conduct was persistent and carried out by the same key players over several years. Defendant Jeffrey McConney prepared or supervised preparation of supporting spreadsheets, while Alan Weisselberg reviewed and approved spreadsheets and, as trustee, certified the statement's accuracy. Donald Trump reviewed and approved statements and certified their accuracy. Don Jr. certified the statement's accuracy as a trustee. Ivanka was involved in numerous real estate deals in America and overseas. The defendants allegedly used this false information year after year, relying on prior years' information to prepare new valuations, continuing the use of deceptive wording in describing valuations performed, and continuing deceptive strategies used in the prior year's statements. So what about the defendant's mental state? Unlike many of the state's anti-fraud laws, the executive law does not require an intent to defraud. The test to determine whether a representation is false is in its capacity to deceive. So what acts go to their capacity to deceive? The Attorney General says that each defendant played a role in certifying false statements about the Trump Organization and its properties, and that they conspired with each other to mislead lenders and insurers. The Trump Organization gave allegedly false statements to banks to induce those institutions to rely on fake numbers. Defendants also went to great lengths to conceal their fraud. When they submitted financial information to Mazars, the Trumps allegedly excluded key information, such as lender-ordered appraisals on a given property, or limitations on development like the easements on Mar-a-Lago. By doing this, defendants hid the correct valuation of individual properties by grouping them together into categories like club facilities and related real estate. The complaint alleges that the defendants also actively engaged in deception, such as failing to disclose the 30% brand premium or avoiding the creation of written records. When Donald and Eric were developing the Seven Springs Club, Mr. Trump and his agents sought to avoid creating a documentary record. Mr. Trump advised his employee handling his real estate affairs in the lower Hudson Valley, which included Seven Springs, that he did not want communications between them put in writing. And this, ladies and gentlemen, is what we call a clue. The second cause of action alleges that the defendants committed repeated fraud or illegality by falsifying business records in violation of state law. Under New York Penal Law, Section 175.05, Falsifying business records is committed when, with intent to defraud, a person A. makes or causes a false entry in the business records of an enterprise, B. alters, erases, obliterates, deletes, removes, or destroys a true entry in the business records of an enterprise, C. omits to make a true entry in the business records of an enterprise in violation of a duty to do so, which he knows to be imposed upon him by law or by the nature of his position, or finally, D. prevents the making of a true entry or causes the omission thereof in the business records of an enterprise. The suit alleges that the Trump Organization kept two sets of books, one that overvalued properties when the business sought loans from banks, and another one that undervalued properties for tax purposes. This is a classic fraud. For example, Trump Park Avenue is one of the crown jewels in the Trump real estate empire. Its value allegedly rose from $90.9 million in 2011 to $350 million in 2021. Unsold residential condominium units owned by Trump or the company represented the lion's share of the reported value for this property, in excess of 95% in some years. So what's the catch? Well, these were actually rent-controlled units. An outside, bank-ordered appraisal in 2010 valued the 12 rent-stabilized units at just $750,000 total. Trump allegedly withheld this appraisal from Mazars and never told Mazars the units were subject to rent control. In the 2020 appraisal, the value of those units rose to $85 million, but the Trump financial statements said that they were valued at $135 million. A lead accountant who was involved in the matter testified that he was shocked by the size of the discrepancy and would never have issued the financial statements if he had been aware of the 2010 and 2020 appraisals and the rent control restriction. This is a classic two sets of books situation. The lawsuit says that all of the defendants issued false financial statements in violation of Penal Law Section 175.45. A person issues a false financial statement under Section 175.45 when the person, with intent to defraud, 1. knowingly makes or utters a written instrument which purports to describe the financial condition of some person and which is inaccurate in some material respect, or 2. represents in writing that a written instrument purporting to describe a person's financial condition as of a particular date is accurate with respect to such person's current financial condition, knowing it is materially inaccurate in that respect. The state alleges that all defendants acted with intent to defraud, knowingly made or uttered materially inaccurate written instruments purporting to describe Donald Trump's financial condition. For example, Trump's 212-acre Seven Springs property consists of 2 large homes, undeveloped land, and a few other buildings. An appraisal prepared by the Royal Bank of Pennsylvania in 2000 estimated the as-is value of Seven Springs at $25 million for residential development, and bank records show that value rose to $30 million in 2006.
Even the heating vents are recessed under 3 inches of marble with small little slits cut out of them.
However, between 2011 and 2021, valuations of Seven Springs ranged from $261 million to $291 million. Why? Because the financial statements were based on projections by Eric Trump, who said that he had gotten approval to build 7 luxurious mansions on the property. The lawsuit alleges that Eric inflated the value of Seven Springs by exaggerating development potential and failing to account for the years of work that were needed to make it happen. The implication of such a valuation is that the lots or homes were ready to sell and would do so instantaneously, a false and misleading and indeed impossible assumption. Eric also allegedly worked to get a federal tax deduction by arranging a so-called conservation easement donation that was based on an inflated value for the land. His attempt to get a conservation easement was a recognition that the Trump Organization would never be able to develop the property for anything approaching a $161 million return. Moving on to insurance fraud. The complaint alleges that the defendants all committed insurance fraud. New York Penal Law Article 176.05 defines insurance fraud as a fraudulent insurance act committed by any person who, knowingly and with intent to defraud, presents to an insurer 1. any written statement in support of an application for the issuance of commercial or personal insurance that he or she knows to a. contain materially false information concerning any fact material, or conceal for the purpose of misleading information concerning any fact material. Or 2, any written statement or other physical evidence as part of the issuance of a health insurance policy or a claim for payment, services, or other benefit pursuant to such policy, contract, or plan that he or she knows to A, contain materially false information concerning any material fact, or B, conceal for the purpose of misleading information concerning any fact material. The complaint says that all defendants prepared and presented written statements in support of applications for insurance, knowing they contained materially false information concerning facts material to those applications. It alleges the defendants also concealed facts from insurers for the purpose of misleading those insurers. The lawsuit provides details on 2 insurance scenarios, where Aon Risk Solutions was the broker and the Trumps are alleged to have submitted false information, a surety bond program with Zurich North America, and directors and officers liability coverages from Everest National and Tokyo Marine HCC. The Trump financial documents were key components in its insurance submissions. They were used to support Trump's personal guarantee in lieu of collateral and to misrepresent the valuations of Trump properties. According to the lawsuit, the Trump Organization only allowed underwriters to review Trump's financial statements in person at Trump Organization offices. The lawsuit alleges that in addition to submitting false financial statements, Trump and his organization failed to disclose an investigation into Trump and other employees that could have affected their ability to obtain directors and officers coverage. Attorney General James claims that the Trump Organization also failed to disclose that the golf courses listed in Trump's statements included a substantial brand premium baked into the reported valuation. Under Zurich's underwriting guidelines, intangible assets like brand value have to be excluded. Had the Trump Organization disclosed the brand premium, Zurich would have reduced that valuation. Finally, the complaint alleges that the defendants conspired to break the law. New York Penal Law, Section 105, generally prohibits a person from entering into a conspiracy to break the law. The Attorney General alleges that defendants are also liable for persistent and repeated fraud under Executive Law 63 sub 12 as participants in a long-running conspiracy. Here, the actions of the defendants, including making numerous false and misleading entries and omissions in financial statements and supporting materials, in a similar manner over the course of more than a decade, and then submitting them to financial institutions as certified by Mr. Trump or his trustees, reflect the existence of an agreement to commit fraud within the meaning of Section 63 sub 12. The state says that it can prove that the defendants committed overt acts in furtherance of the conspiracy as late as 2019, 2020, 2021, and 2022. So the New York Attorney General has said that she can prove it. To get there and to talk about what that proof actually entails, we actually have to talk about the Fifth Amendment. Ratified as part of the Bill of Rights in 1791, the Fifth Amendment is a shield against prosecutorial overreach and a cornerstone of American liberty. The Fifth Amendment provides 5 distinct constitutional rights. 1, the right to indictment by a grand jury for felony charges. 2, prohibition on double jeopardy, meaning you can't be tried for the same crime twice. 3, the right to a fair trial. 4, no government seizure of private property without due compensation. And 5, the right against forced self-incrimination. And today we're just focused on that last one, the right against self-incrimination. The Fifth Amendment provides, in relevant part, no person shall be compelled in any criminal case to be a witness against himself. You've probably heard this right articulated in, say, Miranda warnings, in which the police are required to tell suspects in police custody, you have the right to remain silent. Anything you say can and will be used against you in a court of law.
You have the right to remain silent. If you give up the right to remain silent, anything you say can and will be held against you in a court of law.
So when people take the Fifth or plead the Fifth, it means they've invoked this right against being forced to give testimony that could expose them to criminal liability. The Fifth Amendment's protections cover not just defendants, but witnesses in both civil and criminal settings at the state and federal level. However, pleading the Fifth is frequently misunderstood by lay people and demagogued by politicians, perhaps most famously by Donald Trump himself.
The mob takes the Fifth. If you're innocent, why are you taking the Fifth Amendment?
And of course, as is often the case with all things Donald Trump, there's always a tweet of him saying something in the past that is the exact opposite of what he's saying today. So why are we talking about the Fifth Amendment? because of Trump's deposition. Even getting Trump to sit for a deposition was a Herculean task. In January 2022, the Trump family filed a motion to quash the subpoenas, arguing that ordering the Trumps to testify violated their constitutional rights because their answers could be used in the parallel criminal investigation from the Manhattan District Attorney's Office. In February, a judge rejected those arguments and ordered that the Trumps sit for the deposition. That order was affirmed on appeal in May. Notably, Trump Sr. was also held in contempt of court and fined $10,000 a day for failing to respond to a related subpoena for documents. The elder Trump resolved this contempt finding in May after paying $110,000 in fines. Trump has long attacked the legitimacy of the New York investigation and has even tried to shut it down. In December 2021, Trump and his company filed a federal lawsuit requesting the courts enter an injunction blocking James's office from continuing to investigate them. Trump has also publicly accused Attorney General James, who is black, of being racist and only investigating Trump out of spite and political ambition. When James first ran for Attorney General in 2018, she vowed to investigate Trump if elected, comments that Trump has pointed to as evidence that this is just another witch hunt. In May 2022, a federal judge dismissed Trump's lawsuit, rejecting his claims that he's being targeted out of political animus and allowing the investigation to continue. After delaying the deposition for a month following the death of Trump's first wife, Trump finally sat for the deposition. On August 10, 2022, Trump arrived at James's office in Lower Manhattan in order to comply with the court order to testify. But when the deposition began, the typically loquacious former president had very little to say in response to questioning. A source with knowledge of the deposition said that Trump took the fifth more than 440 times, declining to answer every single question except one. What is your name? The reason for this high number of invocations is that witnesses who seek to invoke their Fifth Amendment rights must assert the privilege in response to particular questions asked or evidence sought. A preemptive blanket assertion of the Fifth Amendment in response to all anticipated questions is not permitted, and any delay or failure to assert one's Fifth Amendment rights may result in a waiver of that privilege. James asked Trump a few preliminary questions, but the vast majority of the deposition was conducted by her deputy. According to Trump attorney Ron Fischetti, Trump repeated the same answer of invoking his Fifth Amendment right not to testify over and over again for the nearly 4-hour deposition. They asked a lot of questions about valuations and golf clubs and all that stuff, Fischetti told the New York Times. Fischetti claimed Trump actually wanted to answer the questions, but had to be talked out of it by his attorneys. He absolutely wanted to testify, and it took some very strong persuasion by me and some others to convince him, Fischetti said. Now, after this deposition, Trump posted the following on Truth Social. A very professional meeting. Have a fantastic company with great assets, very little debt, and lots of cash. Only in America. Trump also put out a more fiery formal statement that called the investigation the greatest witch hunt in the history of our country, and accused James of openly campaigning on a policy of destroying me. Trump also detailed why he had a change of heart about taking the fifth. But in typical Trumpian fashion, he said that even though he's totally innocent, he had no choice but to plead the fifth because everyone is corrupt and out to get him for no reason. I once asked, if you're innocent, why are you taking the Fifth Amendment? Now I know the answer to that question. When your family, your company, and all the people in your orbit have become the targets of unfounded, politically motivated witch hunt supported by lawyers, prosecutors, and the fake news media, you have no choice. Accordingly, under the advice of my counsel and for all the above reasons, I decline to answer the questions under the rights and privileges afforded to every citizen under the United States Constitution. Despite Trump's claim that he had no choice, he did in fact have a choice. After all, his daughter Ivanka and son Don Jr. were deposed by the New York Attorney General's office, and they answered questions instead of pleading the fifth. Also, it might surprise you to learn that Trump was not being entirely truthful about his experience with the Fifth Amendment. I know, it's hard to believe. In fact, Donald Trump is quite familiar with pleading the fifth in far less serious matters. During his contentious divorce with his recently deceased first wife, Ivana Trump, Mr. Trump was asked 100 questions from Ivana's lawyers over the course of 5 depositions that related to marital infidelity. Trump pleaded the fifth in response to 97 of them. Given that the marriage famously fell apart due to Donald's tabloid affair with model, actress, and future wife Marla Maples, Mr. Trump likely calculated he would be better off simply not answering questions about said affair than admitting to it on the record. And that strategy seems to have worked well for him. later bragging that he managed to settle the divorce without giving Ivana a penny more than required by the prenuptial agreement. And even following Ivana's death, Trump seemed to relish not spending a lot of money on the mother of his adult children. Now you might be thinking, hold on a second, I thought we were talking about a civil case and not a criminal case. And you're absolutely right. So let's go back to the complaint. New York's civil fraud complaint makes repeated references to Donald Trump, son Eric Trump, and former Trump CFO Alan Weisselberg repeatedly invoking the Fifth Amendment. In Letitia James's press conference announcing the civil suit, the New York Attorney General also cited Weisselberg and Trump seniors invoking the Fifth Amendment when asked about their potentially fraudulent activities. The implication of James's references is that the defendants had the opportunity to defend themselves from allegations of fraud, but repeatedly chose not to, suggesting consciousness of guilt. But like most things involving Donald Trump, the New York investigation has inspired commentators to adopt some very bad legal takes. Like, for example, senior Fox business editor Jay Caruso, who tweeted, "Invoking constitutional rights is evidence of committing a crime. Great precedent." Now, Caruso's snark aside, he's actually just making an incorrect statement of the law. And I know, a Fox News personality saying something demonstrably inaccurate, there's a first time for everything. When someone pleads the Fifth in a criminal setting, prosecutors may not comment on a defendant's refusal to testify as evidence of guilt, nor may a jury be instructed to interpret a defendant's silence as a sign of guilt. In Griffin v. California, the U.S. Supreme Court ruled that prosecutors may not use a defendant's refusal to testify as substantive evidence of guilt, as doing so would illegally penalize defendants for availing themselves to the Fifth Amendment's constitutional protections. Even though prosecutors can't use defendants' silence against them in criminal cases, that same silence or refusal to answer can have severe consequences in a civil context. That's because in both a private civil case and a state civil enforcement action, a judge or jury can draw adverse inferences to support liability when the defendant invokes the Fifth Amendment, something that is absolutely not permitted in criminal cases. This principle was articulated by the Supreme Court in Baxter v. Palmagano. The Fifth Amendment does not forbid adverse inferences against parties to civil actions when they refuse to testify in response to probative evidence offered against them. The amendment does not preclude the inference where the privilege is claimed by a party to a civil cause. In an August 10, 2022 interview with MSNBC, lawyer and former FBI special agent Asha Rangappa explained just how devastating taking the Fifth could be for Trump against a civil enforcement action.
In a criminal case, a jury cannot draw inferences of guilt from someone asserting their Fifth Amendment right. But in a civil case, a jury can draw an adverse inference, and there's a lower standard of proof. It's a preponderance of the evidence. And in a civil case, though, what Trump is facing are potential financial penalties.
Other legal commentators have noted that while pleading the Fifth helps protect the Trumps from criminal liability, that same refusal to answer questions leaves them quite vulnerable to James's civil action. Former federal prosecutor Renato Mariotti wrote as much on Twitter. The New York AG has a lot of leverage in this lawsuit because Trump and his son Eric took the Fifth hundreds of times. That was smart to do, but it means they're screwed in the civil case. A jury would likely be instructed to presume their answers would have hurt Trump. In short, the reason Caruso's statement is legally incorrect is that it fails to note the distinction between invoking your Fifth Amendment rights in a criminal context versus a civil setting. And in that respect, James isn't creating new precedent so much as she's relying on case law that's existed for nearly 50 years. And when Caruso's misstatement of law was pointed out by national security lawyer Bradley P. Moss on Twitter, Caruso responded with the grace and contrition we've come to expect from Fox News, by which I mean none at all. So that's it. That is the legal basis for the New York State civil enforcement action against Donald Trump, the Trump Organization, his kids, and a bunch of other randos. So on behalf of the LegalEagle, Special Trump Unit, and Devin Sanity, I just want to say, please, for the love of God, can we just end this insane news cycle? Oh God, that's terrible. Oh no. No. Special Trump Unit with the 24-hour news cycle just can't die. Oh no, not again, not another one.
No, we can't. Because if Letitia James is right, as we discussed, she'll use the invocations of the Fifth Amendment to destroy the Trump organization, and there are about to be a whole bunch of Trump org employees and middle-aged Trump adult children that are out of a job. And of course, they could all really benefit from today's sponsor, 80,000 Hours. 80,000 Hours is a nonprofit that helps people find careers that aim to solve the world's most pressing problems. Have you ever taken a career aptitude test where they just ask you to list a bunch of preferences and then it tells you to be like a structural engineer? And you feel confused about what it's based on and what you've been recommended. I know I took tons of those and none of them recommended YouTube lawyer. And that's because most career advice is cookie cutter and it focuses on a few mainstream and obvious paths and doesn't take into account the best available evidence about how to actually find a fulfilling career. And most importantly, relevant career advice can be really hard to find if you care a lot about making a big positive difference in the world. And many sources on this topic only recommend a few well-known career paths that people often think have a high social impact, like, I don't know, being a doctor or teacher or charity worker. Boo! No, those are great, but those aren't your only options, and they probably aren't even your best options. 80,000 Hours is a nonprofit that aims to help you find a career that is both fulfilling and makes a big positive difference. The name comes from the number of hours an average career takes, 40 hours a week, 50 weeks a year for 40 years. That's a lot of time, and that means that your career is probably the biggest opportunity to have an impact. 80,000 Hours has done over 10 years of research alongside academics at Oxford University into how to find a fulfilling career that does a lot of good, and it turns out that the best way to make a positive difference might be pretty different from what you'd think. And they always try to avoid platitudes and unsupported generalizations. In fact, all of their recommendations are based on careful research and consultation with experts in relevant fields. And when they aren't sure of something, they say so. So if you care about what the evidence actually says about having a fulfilling and impactful career, then 80,000 Hours can help. Plus, everything they provide is free forever because they're a nonprofit. Their only aim is to help solve global problems by helping people find the most impactful careers they can. So this one is a no-brainer if you're thinking about your career. If you'd like a free copy of 80,000 Hours in-depth career guide that helps you learn about what makes for a high-impact career, get new ideas for impactful paths, and makes a new plan based on what you've learned, then just click on the link in the description or on the screen right now. You'll get access to their free newsletter with updates on their research and high-impact job opportunities. Again, all you have to do is click on the link that's in the description or on screen right now to start planning for a career that is meaningful, fulfilling, and helps solve some of the world's most pressing problems. And after that, click on this link over here for more LegalEagle, or I'll see you in court.
Election interference.
Former President Donald Trump has been indicted and arraigned for interfering with the 2020 election. The alleged facts of this conspiracy are astounding. Now, we've covered the legality of the crimes alleged, but it's worth exploring the facts of the crimes as well. Prosecutor Jack Smith lays out a story that is as yet unproven in court, but is the most comprehensive look at the conspiracy to overturn and subvert the 2020 election to date. Now, this story takes place in 2 months between November 14th, 2020 and Joe Biden's swearing-in ceremony on January 20th, 2021. The indictment says that the conspiracy started 11 days after the general election. Now, during that time, we got the worst gang of criminals to work with Donald Trump since Harry and Marv in Home Alone 2. This cast of characters is enumerated in paragraph 8, starting with co-conspirator 1, an attorney who was willing to spread knowingly false claims and pursue strategies that defendants' 2020 re-election campaign attorneys would not. You guessed it, give it up for America's mayor, Rudy Giuliani. Co-conspirator 2, an attorney who devised and attempted to implement a strategy to leverage the vice president's ceremonial role, overseeing the certification proceeding to obstruct the certification of the presidential election. That is top Republican legal mind, John Eastman. Co-conspirator 3, an attorney whose unfounded claims of election fraud the defendant privately acknowledged to others sounded crazy. Nonetheless, the defendant embraced and publicly amplified co-conspirator 3's disinformation. You know her from shipwrecks of old. Give it up for Sidney the Kraken Powell. Then there's co-conspirator 4, a Justice Department official who worked on civil matters and who, with the defendant, attempted to use the Justice Department to open sham election crime investigations and influence state legislatures with knowingly false claims of election fraud. He was a lawyer in the Environment and Natural Resources Division until Trump offered to make him acting Attorney General. Yes, this is Assistant Attorney General Jeffrey, we'll call you when there's an oil spill, Clark. Then there's co-conspirator 5, an attorney who assisted in devising and attempting to implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceedings. This is appellate lawyer and humorous name haver Kenneth Cheesebro. Then there is finally co-conspirator 6, a political consultant who helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding. Co-conspirator 6 appears to be Boris Epshteyn, one of Trump's advisors, though this has yet to be confirmed. Epshteyn is best known for writing Trump's controversial Holocaust Remembrance Day speech, in which he omitted any mention of Jewish people. Yeah, this has not been a great day for the legal profession because all 6 of the co-conspirators may in fact be lawyers. These 6 co-conspirators could be indicted in the coming weeks or months, or they could be government witnesses. No one knows at the moment, and it may be up to them. But the bottom line is Trump worked with this cast of co-conspirators to subvert the Electoral Count Act and stop Congress from certifying the election. The ECA governs the process of casting and counting Electoral College votes for president and vice president, and the statute sets forth a timeline for states to appoint presidential elections in November and for electors to cast their votes in December, and describes the process that Congress should follow when it counts the state's electoral votes in January. These days, each state casts electoral votes based on their state's popular vote and then sends their electoral votes along with the state executive's certification that they were the state's legitimate electors to Congress to be counted at an official proceeding. Now, the indictment says that Trump and his cronies organized, quote, fraudulent slates of electors in 7 targeted states, Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, attempting to mimic the procedure that the legitimate electors were supposed to follow under the Constitution and other federal and state laws. The conspirators caused these fake electors to, quote, meet on the day appointed by federal law on which legitimate electors were to gather and cast their votes, cast fraudulent votes for the defendant, and sign certificates falsely representing that they were legitimate electors. One day before Trump was indicted in D.C., 16 of these fraudulent electors were indicted in Michigan for participating in this scheme. And Trump also attempted to use the power and authority of the Justice Department to launch a sham criminal investigation into voter fraud that didn't occur. This apparently included sending a letter outlining false claims that the DOJ discovered massive election irregularities and recommending that these states call a special legislative session to determine, quote, who won the most legal votes and consider appointing a new slate of electors. Now, some of the most troubling allegations involve Jeffrey Clark, the environmental lawyer at the DOJ who Trump wanted to appoint as Attorney General in the waning weeks of his term. Clark met secretly with Trump on December 22nd, failing to inform his superiors of the meeting, which is, of course, DOJ protocol. Now, it's obvious why he didn't tell them. Trump and his allies allegedly tried to get acting Attorney General Jeffrey Rosen to sign a letter that made, quote, knowingly false claims of election fraud to officials in the targeted states through a formal letter under the acting Attorney General's signature, thus giving the defendants' lies the backing of the federal government and attempting to improperly influence the target states to replace legitimate Biden electors with defendants. Now, apparently Rosen wanted nothing to do with this, and on December 26th, he told Clark not to meet with Trump again without notice. Clark said the meeting was an accident and he would abide by Rosen's directive. But the next morning, he had a 3-minute phone call with Trump, and afterwards, Trump met with Rosen and the acting Deputy Attorney General and told them that he was considering replacing Rosen with Clark. Quote, people tell me Jeffrey Clark is great. I should put him in. When Rosen refused to say the election was corrupt, Trump told him to, quote, just say that the election was corrupt and leave the rest to me and the Republican congressman. And of course, people are pointing to this quote as evidence that Trump actually knew that the election was not fraudulent. On December 28th, Clark circulated the letter Trump wanted Rosen to send. And it's important to note here how insane it is that Jeff Clark, who was still officially assigned to the environmental department, was suddenly running point on Trump's maneuvers with the DOJ. He was sending his boss, Jeff Rosen, the same letter that Rosen had already refused to sign. Clark proposed sending versions of this to battleground states that Biden won. And here's the claims made in that letter, which the government says are false. The Justice Department had, quote, identified significant concerns that may have impacted the outcome of the election in multiple states. The Justice Department believed that in Georgia and other states, 2 valid slates of electors had gathered at the proper location on December 14th, and that both sets of ballots had been transmitted to Congress. That is, co-conspirator 4, Jeff Clark's letter sought to advance the defendant's fraudulent elector plan by using the authority of the Justice Department to falsely present the fraudulent electors as a valid alternative to the legitimate electors. The Justice Department urged the state legislature to convene a special legislative session to create the opportunity to, among other things, choose the fraudulent electors over the legitimate electors. But Rosen rebuffed Clark again and told him not to engage with Trump. On New Year's Eve, Trump summoned Rosen and other DOJ lawyers and told them he might have to change leadership at the DOJ. Now, the Justice Department traditionally operates fairly independently from the White House. Presidents aren't supposed to order the Attorney General to make legal decisions, but here was Trump insisting that they send the letter. And on January 2nd, Clark continued his insubordination by asking his boss and others to sign the letter Trump wanted to send. He told them that Trump was considering firing Rosen and replacing him with Clark, but that he'd decline the job if Rosen would just cave and send the letter with false fraud allegations. On January 3rd, Clark revised the fraud letter, changing its language about concerns to a stronger false claim that, quote, as of today, there is evidence of significant irregularities that may have impacted the outcome of the election in multiple states. Now, that was apparently enough for Trump to give him the acting attorney general job because the two met and Clark accepted the job. So Clark spent all day scheming with Trump and testing the limits of the new power. Now, apparently, quote, a deputy White House counsel tried to dissuade Clark from assuming the role of acting attorney general. The deputy White House counsel reiterated to co-conspirator 4, Jeff Clark, that there had not been outcome-determinative fraud in the election and that if the defendant remained in office nonetheless, there would be, quote, riots in every major city in the United States. Jeff Clark responded, quote, well, Deputy White House counsel, that's why there's an Insurrection Act. Clark apparently then called his boss and told him that he was now the acting attorney general. Rosen, quote, responded that he would not accept being fired by a subordinate and immediately scheduled a meeting with the defendant for that evening. But there was apparently a very strong push by the Justice Department attorneys to stop Trump and Clark from implicating the DOJ in overturning a valid election. In fact, Trump only gave up on his plan to install Clark as AG after, quote, he was told that it would result in mass resignations at the Justice Department and of his own White House counsel. Of course, mass resignations are not something that happen every day, and if the Justice Department lawyers resigned en masse, then it would probably have blown the whistle on what the conspirators were trying to do. Jeffrey Clark drafted a letter to Georgia saying, quote, the Department of Justice is investigating various irregularities in the 2020 election for President of the United States. The department will update you as we're able on investigatory progress, but at this time we have identified significant concerns that may have impacted the outcome of the election in multiple states, including the state of Georgia. Now, this was false. The DOJ plays no role in certifying the winner of the presidential election. State investigations and audits confirm that Biden won the state, and every court which considered the issue ruled against Trump. But the indictment has a whole section on Trump's efforts to overturn the Georgia election results. Now, this section of the indictment is pretty funny because it actually describes two different methods of attack Trump took, one with Sidney Powell and the other with Rudy Giuliani. Now, the Powell method only takes up one paragraph because her lawsuit was dismissed so quickly and obviously, but it has some great details. On November 16th, Trump's, quote, executive assistant sent Powell and others a document containing bullet points critical of a certain voting machine company, writing, see attached, please include as is or almost as is in lawsuit. Co-conspirator 3, Sidney Powell, responded 9 minutes later, writing, quote, it must go in all suits in Georgia and Pennsylvania immediately with a fraud claim that requires the entire election to be set aside in those states and machines impounded for non-partisan professional inspection. Now, I can only assume that this was a reply all given the abundance of all caps, but the indictment does not say. 9 days later, Powell filed a lawsuit, quote, against the governor of Georgia, falsely alleging massive election fraud accomplished through the voting machine company's election software and hardware. In the next chunk of the paragraph, we have a vindication of Trump's ability to actually assess legal issues. Quote, before the lawsuit was even filed, the defendant retweeted a post promoting it. The defendant did this despite the fact that when he had discussed co-conspirator 3's far-fetched public claims regarding the voting machine company in private with advisors, the defendant had conceded that they were unsupported and that co-conspirator 3 sounded, quote, crazy. Co-conspirator 3's Georgia lawsuit was dismissed on December 7th. It's actually kind of refreshing to hear Trump be right on the money for once. Sidney Powell is in fact crazy, but this may be a broken clock type situation. But in the next paragraph, though, the DOJ goes on to the much more worrisome moves by Trump and Rudy Giuliani to pressure Georgia Secretary of State Brad Raffensperger into overturning the state's election results. Basically, Trump and Giuliani and Raffensperger go back and forth with Raffensperger and other Georgia officials calmly and repeatedly telling Trump that there were neither dead nor illegitimate voters in large numbers in Georgia. Eventually, this defeatist attitude infected Trump's own team. Quote, as early as mid-November, for instance, the senior campaign advisor had informed Trump that his claims of a large number of dead voters in Georgia were untrue. With respect to the persistent false claim regarding State Farm Arena, on December 8th, the senior campaign advisor wrote in an email, when our research and campaign legal team can't back up any of the claims made by our elite strike force legal team, you can see why we're 0-32 in our cases. I'll obviously hustle to help on all fronts, but it's tough to own any of this when it's all just conspiracy beamed down from the mothership. Yes, believe it or not, the Trump camp did actually refer to this group of some of the worst lawyers who have ever practiced in America as the elite strike force legal team. Now, as you can probably tell, Trump is probably going to need a really good lawyer based on these facts. But if you need a great lawyer, my firm, the Eagle Team, can help. If you've had an injury or death in the family, suffered a data breach, or were involved in a car crash, we can represent you or help find the right attorney who can. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. The link is down below. But of course, all this stuff is a little silly and easy to make fun of now, but at the time, Giuliani and Trump singled out and harassed individual election staffers. Quote, at the hearing before the Georgia House of Representatives Government Affairs Committee, Giuliani played the State Farm Arena video again and falsely claimed that it showed voter fraud right in front of people's eyes and was the tip of the iceberg. Then he cited 2 election workers by name, basically accusing them of quite obviously surreptitiously passing around USB ports as if they are vials of heroin or cocaine. These workers were Shane Moss and Ruby Freeman, who subsequently received numerous death threats. Shane Moss testified before the January 6th committee about what actually happened.
Mr. Giuliani accused you and your mother of passing some sort of USB drive to each other. What was your mom actually handing you on that video?
A ginger mint.
And in other testimony, Ruby Freeman described how unsafe Giuliani and Trump's actions made her feel in her own community.
Now I won't even introduce myself by my name anymore. I get nervous when I have to give my name for food orders. Around the week of January 6th, the FBI informed me that I needed to leave my home for safety.
Understood. How long did you stay out? Did you remain outside of your home?
I stayed away from my home for approximately 2 months.
And Trump continued to drag Freeman and Moss's names through the mud in his now infamous perfect call with Brad Raffensperger.
Having to do with Ruby Freeman, she's a vote scammer, a professional vote scammer and hustler.
And later in the call, Trump, of course, asked Raffensperger to find 11,780 votes for him.
I just want to find 11,780 votes, which is one more than we have, because we won the state.
Similarly, on December 7th, despite still having established no fraud in Michigan, co-conspirator 1 sent a text intended for the Michigan Senate Majority Leader, quote, so I need you to pass a joint resolution from the Michigan legislature that states that the election is in dispute, there's an ongoing investigation by the legislature, and the electors sent by Governor Whitmer are not the official electors of the state of Michigan and do not fall within the safe harbor deadline of December 8th under Michigan law. Now, I'd be curious to hear why the indictment says that Giuliani intended that text to be sent to the Michigan Senate Majority Leader. Did he send that to someone close to the Majority Leader who would then pass along the message? Or did he actually send that to someone who wasn't connected at all, who then turned it over to the FBI? Hopefully we'll get an answer to that question. Anyway, quote, on December 14th, the Michigan House Speaker and Michigan Senate Majority Leader announced that contrary to the defendant's requests, they would not decertify the legitimate election results or electors in Michigan. Now, about a month after trying to dupe state electoral officials, Trump and his merry gang, quote, developed a new plan to marshal individuals who would have served as the defendant's electors had he won the popular vote in 7 targeted states, Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, and cause those individuals to make and send to the vice president and Congress false certifications that they were legitimate electors. Under the plan, the submission of these fraudulent slates would create a fake controversy at the certification proceeding and position the vice president presiding on January 6th as president of the Senate to supplant legitimate electors with the defendant's fake electors and certify the defendant as president. Paragraph 58 has a fun account of how this would have gone down, as recalled by an Arizona attorney invited to be a fake elector. The next day, on December 8th, Kenneth Chesebro called the Arizona attorney on Boris Epstein's list. In an email after the call, the Arizona attorney recounted his conversation with Chesebro as follows. I just talked to the gentleman who did that memo, Ken Chesebro. His idea is basically that all of us have our electors send in their votes, even though the votes aren't legal under federal law because they're not signed by the governor, so that members of Congress can fight about whether they should be counted on January 6th. They could potentially argue that they're not bound by the federal law because they're Congress and make the law, etc. Kind of wild/creative. I'm happy to discuss. My comment to him was that I guess there's no harm in it, legally at least, i.e., we would would just be sending in fake electoral votes to Pence so that someone in Congress can make an objection when they start counting votes and start arguing that the fake votes should be counted. Couple little fun editorials by this attorney that I want to point out. First, he points out that the fake electors would be illegal under federal law. Then the lawyer pivots to conclude that the scheme would result in congressional debate that legally at least would do no harm. There's no harm in it legally at least is doing a lot of heavy lifting, like Schwarzenegger levels of lifting, like Joan Rivers levels of lifting. And secondly, wild/creative is probably how you want to describe an ugly drawing that your friend's kid made, not really a plan to overturn the presidential election. But if you encounter a legal theory that is wild/creative, you should probably travel expeditiously in the other direction. Now, the other people familiar with Trump's plan, namely his co-conspirators, absolutely refused to stand by it when push came to shove. Quote, on December 13th, the defendant asked the senior campaign advisor for an update on what was going on with the elector plan and directed him to put out a statement on electors. When the senior campaign advisor related those developments in text messages to the deputy campaign manager, a senior advisor to the defendant, and a campaign staffer, the deputy campaign manager responded, "Here's the thing. The way this is morphed, it's a crazy plan, so I don't know who wants to put their name on it." And it continues. The senior advisor wrote, certifying illegal votes. In turn, the participants in the group text message refused to have a statement regarding electors attributed to their names because none of them could stand by it. Now, the indictment also alleges that Trump put extreme pressure on Mike Pence, including putting a damper on what I can only assume was a very bland Christmas dinner. On Christmas Day, Pence called Trump to wish him a Merry Christmas, but Trump steered the conversation to the election, leading Pence to tell him, "You know, I don't think I have authority to change the outcome." And here the indictment cites to the vice president's contemporaneous notes to allege that Trump told Pence that the DOJ was finding major infractions. And that happened on December 29th, long after multiple DOJ officials told Trump that there was actually no fraud. On January 1st, 2021, Trump allegedly berated Pence for refusing to go along with his proposal. In response, the defendant told the vice president, "You're too honest." Then on January 4th, Trump met with Pence, one of the co-conspirators, the vice president's chief of staff, and the vice president's counsel to convince Pence that he should reject Joe Biden's electoral votes or resend them back to the states. During the meeting, as reflected in the vice president's contemporaneous notes, the defendant made knowingly false claims of election fraud, including, "Bottom line, won every state by hundreds of thousands of votes," and "We won every state." Side note, Mike Pence is now selling merch that says "Too honest" to capitalize on this historic moment. Trump met with Pence again on January 5th to convince him to overturn the election, but when Pence refused, Trump, quote, grew frustrated and told the vice president that the defendant would have to publicly criticize him. But, quote, upon learning this, the vice president's chief of staff was concerned for the vice president's safety and alerted the head of the vice president's Secret Service detail. Later that day, Trump tweeted that, quote, "The vice president and I are in total agreement that the vice president has the power to act." As an aside, this is probably important because it shows that Trump wasn't just lying about whether he believed he won the election. As far as we know, Pence never agreed with Trump that the vice president had the legal authority to do what Trump wanted him to do. And the indictment says that Trump lied about Pence's intentions, which theoretically moved the conspiracy forward. And on January 6th, Trump tweeted about Pence repeatedly. Staffers from Senator Ron Johnson's office sent the fraudulent certificates to Pence's office, but a Pence staffer refused to accept them. The indictment says Trump exploited the violence at the Capitol to pressure Pence. When staffers left him alone in the dining room, he tweeted that, quote, Mike Pence didn't have the courage to do what should have been done to protect our country. And just 1 minute later, the Secret Service had to evacuate the vice president to a secure location. They took Pence to a place where he could never be found, presumably a room with a woman in it. But, quote, upon learning this, the vice president's chief of staff was concerned for the vice president's safety and alerted the head of the vice president's Secret Service detail. While Mike Pence was hiding from writers, Trump took this opportunity to pressure lawmakers into delaying the certification, and Trump had Giuliani call 5 senators and a representative. In one of the calls, co-conspirator 1 left a voicemail intended for a United States senator that said, "We need you, our Republican friends, to try to just slow it down so we can get these legislatures to get more information to you. And I know they're reconvening at 8 tonight, but the only strategy we can follow is to object to numerous states and raise issues so that we get ourselves into tomorrow, ideally until the end of tomorrow." And later that night, Giuliani claimed that illegal immigrants had voted in substantial numbers in Arizona and that Georgia gave you a number in which 65,000 people who were underage voted. Now, Trump supporters insist that Trump really believed the election was stolen, and we covered the implications of Trump's mental state in the prior video that we did on this. And while I suppose anything is possible, it's hard to believe when he was being rebuffed so strongly by the Justice Department and so many other people at the same time. especially because lawyers and advisors kept telling Trump that he lost. One deputy White House counsel apparently said, quote, "There is no world, there is no option in which you do not leave the White House on January 20th. And it is alleged that Trump acknowledged privately that he lost. For example, after the chairman of the Joint Chiefs of Staff urged Trump to not take action on a national security issue, Trump agreed, saying, quote, "Yeah, you're right, it's too late for us, we're going to give that to the next guy." That was on January 3rd, just 3 days before the Trump-inspired voters came to the Capitol and interrupted the certification. And the New York Times reports that the special counsel had access to a previously unseen internal memo from the 2020 Trump campaign describing in detail the plot by Donald Trump and his lawyers to subvert the election results in 6 states. The memo was written by Ken Cheeseborough, and it describes a 3-pronged plan to prevent Congress from certifying Joe Biden's victory on January 6, 2020. The memo was sent to a Wisconsin lawyer, James R. Trupis, the lead attorney for the Trump campaign in Wisconsin, who oversaw the fake elector scheme in his state. Quote, "Trupis filed a lawsuit in December 2020 asking the Wisconsin Supreme Court to throw out hundreds of thousands of absentee ballots, saying they violated voting requirements. The court ultimately rejected the lawsuit." Now, Cheeseborough wrote to Trupis saying, quote, "It seems feasible the Trump campaign could subvert Biden's victory. His plan would, quote, force the members of Congress, the media, and the American people to focus on the substantive evidence of illegal election and counting activities in the 6 contested states, provided 3 things happen." And according to Cheeseborough's plan, quote, "Republican electors in all 6 states, Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin, would meet and cast votes for Trump on the 14th of December, 2020, the deadline for electors to send their votes to Congress for certification in January. Attorneys in each of the 6 states would simultaneously file lawsuits that would lead to either a Trump victory or a Biden loss, which would be pending on the 6th of January, the certification date. And then finally, on the day that Congress meets to certify the electors' votes, quote, Pence, presiding over the joint session, takes the position that it is his constitutional power and duty alone as president of the Senate to both open and count the votes, and that anything in the Electoral Count Act to the contrary is unconstitutional. Now, before Donald Trump goes to jail, I'm sure he'd love to have one last home-cooked meal, which you can do with today's sponsor, because with HelloFresh, you can make it exactly how you want, even cooked extremely well done and slathered in ketchup. You know, you do you. But fall is right around the corner, and HelloFresh is here to help you plan for a busy season ahead with tasty dishes delivered to your door. Simply choose the recipes and pick your delivery date, and then lay back and enjoy the last days of summer knowing that dinner is covered. HelloFresh keeps your taste buds on their toes with 40 chef-crafted recipes that you can select from every week. From family-friendly to fit and wholesome, you'll always find something new and exciting to try and love. HelloFresh is a great way to eat delicious, fresh food while still being healthy. Now, I'm a do-it-yourself person, and I have to say I was initially pretty skeptical about HelloFresh. I'm a pretty good cook, so I didn't think that I needed the help, but I actually loved it. Even for an experienced cook, HelloFresh delivers new ingredients and recipes that I would never try on my own. And of course, everything was delivered straight to my door, so I didn't have to do any shopping. The produce actually gets to you faster than a grocery store, so it arrives at peak freshness and flavor. And it's also super easy to save time. HelloFresh cuts out the meal planning and prep, so the recipes only take 20 to 30 minutes to cook, literally less time to cook than it would normally take to do the shopping. And HelloFresh is at least 25% cheaper than takeout. So if you'd like to try HelloFresh, go to HelloFresh.com and use the code 50LegalEagle at checkout for 50% off plus free shipping. Yes, you can actually get 50% off plus free shipping by clicking on the link that's on screen right now or down in the description. So click on the link below and use the code 50LegalEagle at checkout. After that, click on this link over here for more LegalEagle, or I'll see you in court. Writers and actors are striking in sunny California, and a movie studio just so happened to trim the city's trees that were providing shade to the protesters. You know what that means. It finally happened. We're talking tree law, baby. Yee, tree law finally happened, yay! All right, so the city of Los Angeles has fined NBC Universal $250 after the company trimmed ficus trees that striking writers and actors were using for shade while picketing at the Universal Studios lot. Was this a deliberate attempt to hurt the strikers during an unprecedented heat wave, as the mayor and strikers alleged? And if so, then why is Universal only getting a slap on the wrist? Or was it just a simple misunderstanding and coincidence? Well, welcome to the wild world of tree law. Now, on July 17th, writer and SAG member Chris Stevens shared a photo of a row of ficus trees outside of the Universal Studios lot in Los Angeles. Quote, quick shout out to the good people at Universal Pics for trimming the trees that gave our picket line shade right before 90+ degree week. It appeared that the trees had their branches and leaves trimmed down over the weekend. When strikers showed up for the picket line on Monday, they found that their shade was gone. And in the photo, you can see the before and after that Stevens referred to. Stevens and the other strikers suggested that the tree trimming was a pretext to take shade from striking SAG-AFTRA workers. The union's 160,000 members went on strike in July, along with the 11,000 Writers Guild of America members who have been on strike since May. Now, in most cities, you can't just trim or remove trees without a permit. As most people on the internet seem to know. In Los Angeles, these trees are along a sidewalk that is considered public property. Their maintenance is under the jurisdiction of the Urban Forestry Division of the Bureau of Street Services. The Urban Forestry Division manages nearly 700,000 street trees, growing along 6,500 miles of public roads, making the city of Los Angeles' street tree population the largest urban forest in the nation and possibly the world. And Streets LA has a website where you can actually look up all 700,000 trees in the city. And when I type in 3801 Barnum Boulevard into the search site, it pulls up those that line the streets that are in question here. And since so many people have a passion for tree law, yes, I see you 78,000 members of Reddit's Tree Law Forum, let me do a quick rundown on this apparently intoxicating legal speciality. In the United States, state and local governments have jurisdiction over tree laws. Tree law governs issues like who owns trees, how neighbors handle tree disputes, whether a tree is on government property, when trees become hazardous, and whether a person can cut down trees on their own property. Now, generally, if your neighbor's tree branches or roots cross onto your property, you can cut them down if they're creating a hazard. However, if you damage your neighbor's tree in the process, you might have to pay for the damage. Now, tree law is a very thorny issue, but if you need to branch out and get a great lawyer, my firm, the Eagle team, can help. If you've been in a car crash, suffered a data breach, or have Social Security disability issues, we can represent you or help find you the right attorney who can. Just click on the link in the description for a free consultation with my team, because you don't just need a legal team, you need the Eagle team. The link is below. Now, Los Angeles has special rules for protected trees, covering mostly oak trees that are indigenous to California. Illegal pruning or willful damage to protected oak trees can result in a $10,000 fine and or 6 months in jail. The city also protects heritage trees, which are, quote, individual trees of any size or species that are specifically designated as heritage because of their historical, commemorative, or horticultural significance. There are steep fines for damaging trees with historical significance, like the Tuna Canyon Detention Station's Tahunga Oak Grove. These trees are the last remnant of a World War II era Japanese detention camp. The ficus trees outside of Universal Studios lot located at 3801 Barnum Boulevard are not protected or historical. Instead, they are considered, quote, a parkway tree. A parkway tree is a tree that is planted by Public Works or the developer who built the building adjacent to the edge of the roadway. Now, for parkway trees, the city follows the recommendations of the International Society of Arboriculture, which generally recommends that most trees be trimmed during the dormant season. The dormant season for ficus trees is fall or winter. Arborists were also concerned about the way the universal trees were trimmed because they appear to have been topped. Now, topping is the removal of the top of the central stem of a tree, called the leader, as well as the upper main branches. Now, Los Angeles has formally adopted the American National Standard Institute's pruning standards. The ANSI says, quote, topping and lion's tailing shall be considered unacceptable pruning practices for trees. Universal told Deadline to, quote, prune these trees annually at this time of the year. Though one Constantine Anthony, a member of SAG-AFTRA, questioned whether this was true.
We can't find any work orders done for this particular tree trimming, which is problematic. In Southern California, we have a lot of laws governing trees. Normally, you don't trim until October. And in fact, the exact same style and type of tree, about 200 feet this way, are not trimmed. But those aren't providing shade to the picketers, are they?
LA City Controller Kenneth Mejia investigated the matter and said his office hadn't given Universal a tree trimming permit in 3 years. He concluded that Universal should have gotten a permit. And Mejia fined NBC Universal $250 because that is the maximum penalty allowed for a first-time offender. He tweeted that, quote, Streets LA fines all first-time offenders, regardless of the number of trees at issue, a $250 penalty. If violations continue, the fines can grow to $1,000. If trees are found to be significantly damaged, LA can require the offenders to plant 2 trees per damaged tree. Now, I should note, as a longtime former resident of Los Angeles, I've seen these kinds of trees all over the city of LA and often pruned in this manner. I have no idea whether people are getting permits for this kind of thing, but it also seems like a lot of people tend to prune these kinds of trees in the summertime. So at least from that aspect, anecdotally, in my own personal experience, it doesn't seem that out of character. And in this case, Streets LA determined that the trees didn't suffer significant damage and would easily recover in 6 to 12 months. Mejia pointed out that LA's 12 tree inspectors have the impossible job of monitoring over 700,000 trees, and he said the system isn't working as intended. And as much as I'd love to demonize the movie studios here, another issue with these kinds of trees is that they grow so fast that they often tend to interfere with traffic. So it wouldn't be surprising if one wanted to err on the side of trimming the trees rather than letting them grow wild, which literally can impact the cars that are driving by. But the city's fine here isn't the end of the story between the unions and Universal. Both SAG-AFTRA and the WGA filed formal unfair labor practice charges against Universal. An unfair labor practice, referred to as a ULP, is an action by an employer or a union that violates the National Labor Relations Act. And the NLRA was passed in 1935. Its aim is to encourage collective bargaining between workers and employers. And the NLRA gives employees the fundamental right to seek better working conditions without fear of retaliations. Now, classic examples of a ULP by an employer include firing or penalizing employees who exercise any of the rights under the NLRA, including the right to picket an employer, as those striking actors and writers were doing outside of the Universal lot. And the SAG-AFTRA charge says, quote, Universal was interfering with lawful picketing activity by designating as picketing locations areas where the public sidewalks have been covered up with construction fencing, forcing picketers to patrol in busy streets with significant car traffic, where 2 picketers have already been struck by a car, and by refusing to provide K-rail barriers to establish pedestrian walkways for picketers to use after Los Angeles Police Department advised the employer weeks ago in the interest of public safety to do so. The union said that this was suspiciously timed construction and that the loss of tree shade during a record heat wave has forced SAG-AFTRA to determine that it cannot safely send its members to picket at NBC Universal. Now, Universal said it regretted that its decision, quote, created unintended challenges for demonstrators. That was not our intention. In partnership with licensed arborists, we have pruned those trees annually at this time of the year to ensure that the canopies are light ahead of the high wind season. Now, it's certainly possible that this was simply a coincidence and not a ULP, we just don't know. But it's also important to look at why the unions are striking in the first place. Because for the first time since Ronald Reagan was the union boss, yes, that is actually a thing that happened, the unions representing actors and writers are staging a strike at the same time. The actors and writers are negotiating with the Alliance of Motion Picture and Television Producers, or AMPTP, and the AMPTP represents major studio bosses and producers such as Sony, Universal, Paramount, Walt Disney Studios, Warner Brothers, plus major streamers like Netflix, Amazon, and Apple TV+. And the strikers are concerned about a number of different topics, including low pay, residuals, streaming, and the use of AI. And those topics probably require their own dedicated video. And while YouTubers aren't generally members of these unions, we definitely know what it feels like to be screwed over by movie studios and television producers. So if you'd like to support the unions in their negotiations, you can donate to the link that's down in the description, including SAG-AFTRA's Emergency Financial Assistance Program, which gives emergency financial aid to members with great urgent need. And their Green Envelope Grocery Aid provides grocery assistance to striking writers and actors. And if you know any striking actors or writers, you can get them groceries directly with today's sponsor, HelloFresh. Absolutely everyone loves HelloFresh. And if you already have a HelloFresh subscription, why not get a subscription for one of these striking writers or actors? Because HelloFresh is a great way to eat delicious fresh food while still being healthy. It's a great way to get back into a diet or just eat great food. In fact, HelloFresh has a whole variety of calorie smart, carb smart, pescatarian, and veggie options. You can customize it how you like too. HelloFresh delivers fresh, quality produce from the farm to your door in less than a week. Right now, they have summer favorites from backyard bratwurst bars to tangy key lime pie. Now, I'm a do-it-yourself person, and I have to say, I was initially pretty skeptical about HelloFresh. I'm a pretty good cook, so I didn't think that I needed the help, but actually, I loved it. Even for an experienced cook, HelloFresh delivers new ingredients and recipes that I would never try on my own. And of course, everything was delivered straight to my door, so I didn't have to do any shopping. The produce actually gets to you faster than a grocery store, so it arrives at peak freshness and flavor. And it's also super easy to save time. HelloFresh cuts out the meal planning and prep, so the recipes only take 20 to 30 minutes to cook. Literally less time to cook than it would normally take to do the shopping. And HelloFresh is 25% cheaper than takeout. So if you'd like to try HelloFresh, go to HelloFresh.com and use the code LegalEagle50 at checkout for 50% off plus free shipping. Yes, you can actually get 50% off plus free shipping by clicking on the link that's on screen or down in the description. So click on the link below and use the code LegalEagle50 at checkout. After that, click on this link over here for more Legal Eagle, or I'll see you in court. Buying Twitter might be the worst thing to ever happen to Elon Musk, but the best thing to happen to people who love crazy lawsuits. And now Elon is suing the lawyers who forced him to follow through with the sale because he thinks that they charged Twitter too much to beat Elon Musk, because now Elon owns Twitter and he's the one that effectively has to pay for it. You really can't make this up. But of course, it's more complicated than that. Now, apparently Musk is still smarting from the time that he was forced to honor his deal to buy Twitter for $44 billion. So now he has filed a lawsuit against the law firm of Wachtell, Lipton, Rosen and Katz, the law firm which represented Twitter when the old owners sued Musk to follow through with the sale. Wachtell charged Twitter $90 million to facilitate the deal that eventually led to Musk taking Twitter private. Now, the old Twitter board paid $84 million right as the deal closed, literally 10 minutes before the company turned over to Musk, and now Elon would like all of that money back, please.
Money, please.
Now, to review, this was a sale between a public company and an individual who intended to take the company private. Musk offered Twitter a share price of $54.20 per share, and Twitter's board accepted the deal. Musk then tried to back out of the deal for reasons relating to him being a huge idiot, and essentially Musk failed to do his due diligence before making the offer and later realized that his offer was way too high. Or maybe it dawned on him that trying to make Twitter profitable was going to require a lot more than just shitposting on Twitter, so he tried to get out of it. Now, Wachtell wasn't Twitter's original law firm for the sale, but when Musk said that the deal was dead and tried to back out, Twitter turned to this law firm, which has a reputation as one of the world's top law firms specializing in mergers and acquisitions.
I'm into, murders and executions mostly.
Wachtell promptly sued Musk in the Delaware Court of Chancery, and he backed down without even getting a discount on the original sale price. Basically, they spanked him. Now, right before the deal closed, Twitter paid the law firm $90 million in success fees. Elon Musk believes that this is unjust enrichment, and the firm should give most of that back to Twitter, which he now owns. And the timeline breaks down like this. Twitter hired Wachtell on June 21st, 2022. The law firm sent an engagement letter stating it would represent Twitter, quote, on an hourly fee basis in a litigation to compel specific performance of the Musk party's acquisition of Twitter. This engagement letter doesn't contain any language about a success fee. Now, the engagement letter indicates that Wachtell negotiated an exemption from Twitter's usual fee arrangement with outside counsel, which gave Twitter a 15% discount on hourly billing rates. And in the months of work after making this arrangement with Twitter, Wachtell invoiced Twitter for a total of $18 million, including $15.6 million in hourly fees. Musk characterizes that as outrageous because it was only for a few months of work. Now, what the complaint leaves out is that during those few months, Wachtell filed a lawsuit against Musk that successfully compelled him to go forward with the sale. And the lawsuit was filed on July 12, 2022. By October 4th, 2022, Musk gave up his fight to back out of the sale, and he agreed to abide by the deal's original terms, and the closing was set for October 28th. Now, according to the complaint, on October 27th, with, quote, the firm's work on the merger litigation in the Delaware Chancery Court already concluded, and without any foreseeable need for Twitter to utilize its services again, Wachtell, the law firm, decided to milk the company for $90 million in success fees. Musk says, quote, in other words, Wachtell sought and obtained a success fee that resulted in a total fee nearly 6 times its $15.6 million in invoiced hourly fees for a few months' work, even though 1, it was not called for by any prior agreement with Twitter, and 2, the litigation in which Wachtell represented Twitter had been stayed for weeks in anticipation of dismissal following the closing. Now, you might be asking why a success fee is even a thing, and why a company would agree to pay a success fee over hourly billing. Well, many clients are concerned that outside law firms run up billable hours by overstaffing cases with too many lawyers or generating work that isn't necessary. And the theory goes that if you align the financial incentives of the client and the law firm is less likely to do a bunch of unnecessary work and waste the client's money. And Bloomberg reports that Wachtell was, quote, one of the first law firms to link its fees to the value of successful deals rather than linking them to hourly billing rates like many of its peers. And in this way, the law firms are acting more like banks, which tie their fees to a percentage of the deal when it's completed. And the exhibits attached to the complaint include a memo from Wachtell explaining that, quote, while our fees are not based on the amount involved in a matter, experience indicates that merger and acquisition and takeover fees have typically ranged from 1% or more on matters under $250 million and 0.1% or less on matters over $25 billion. Wachtell argues that the value of its advice can't be demonstrated by a simple hourly rate. It's a classic line from lawyers. Absolutely always the case.
I'm like a god in human clothing. Lightning bolts shoot from my fingertips.
But the difference here is that Wachtell didn't start out the engagement with a success fee specified. And Musk's complaint is that it was improper for Wachtell to switch from an hourly billing arrangement to a success fee structure on the eve of closing. Yeah, this is one of those cases that's going to be really fun to watch because at the end of this case, at least one of these parties is going to lose. Now, Musk's first claim is for unjust enrichment. He claims that the closing day letter agreement between the board of directors and the law firm, quote, called for payment of an unconscionable fee and was an unconscionable agreement. Musk argues that Twitter's board of directors were a bunch of losers who got totally hosed by the law firm. The complaint describes them as, quote, lame duck fiduciaries who, quote, lost their motivation to act in Twitter's best interest during the sale. Though one would argue here the complete opposite, that the board was in fact extremely motivated to close the sale at the original price, which arguably was in the best interest of the shareholders. But Musk's perspective is that it was clearly not in Twitter's best interest to have paid this enormous legal bill. But that misunderstands what their duties actually were between signing and closing. Their legal fiduciary duty was to make sure that the deal maximized the value for Twitter's shareholders. That's all they had to do. And the lame duck fiduciaries executed that responsibility beautifully by forcing Musk to buy Twitter at an extremely high share price. And if they accomplished that, then the shareholders didn't care what else Twitter did with its money because it was no longer theirs. And in fact, because the share price was already set by Elon Musk, it didn't really matter how much they paid out to the lawyers because that wasn't going to change how much the shareholders ultimately got. Though it really made a big dent in Elon Musk's pocket when he had to pick up the pieces of Twitter when he bought it. And yes, $90 million is a lot of money, but were the lawyers' fees beyond the pale in this particular case? Well, in contract law, if the terms of a contract are unfair or oppressive to one party in a way that suggests abuse during its formation, a court can find it unconscionable and refuse to enforce it. But courts rarely find unconscionability in a business dispute between two fairly equal parties. A contract is most likely to be found unconscionable if both unfair bargaining and unfair substantive terms are shown. And generally, courts only void a contract on unconscionability grounds in extreme cases. There's one famous case where a loan interest rate was 800%, or an instance where a warranty expires before a product is even installed. Basically, things that really shock the conscience. Not really things like a relatively high bill for litigation that won billions of dollars. But, you know, your mileage may vary. Now, speaking of great lawyers, my firm, the Eagle team, is now accepting new clients, and we don't charge $90 million. If you've been in a car crash, a data breach, or medical malpractice, or just about anything else, we can represent you or help find you the right attorney who can. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is down below. And now back to Elon Musk. Now, Wachtell is one of the premier mergers and acquisitions firms, and its partners make serious bank by charging success fees. And in the firm's fee arrangement memo, Wachtell outlined its comparables, explaining that its success fees generally range from 67% to 100% of the investment banking fees. And the memo also says that the fee could be a multiplier of its hourly billing or run rate. And during the first 4 months, the lawyers billed $26.6 million, and the success fee is about 2.5 times that amount, which was within comps Wachtell gave to Twitter. And the banks, JP Morgan and Goldman Sachs, got $133 million, with $113 million of that as a success fee when the buyout closed. So the $90 million that Musk complains about was around 68% of the bankers' fees, which is actually on the lower end of comparables, if you are to believe Wachtell. But Musk argues that the success fee is too much because litigation didn't move forward and Wachtell wasn't the law firm involved in the original negotiation between Musk and Twitter. And that's an argument, but it's probably not particularly strong. To prove his point, Musk states that the work that the lawyers did wasn't particularly hard, since it was just a garden variety contract dispute. Quote, there were no novel or difficult questions of law involved, nor did the litigation require any special skills beyond that which Twitter could have procured by paying hourly rates to many other reputable law firms with the experience litigating in the Delaware Chancery Court, including those hired to work alongside Wachtell. Now, this argument is particularly hilarious because Musk is actually admitting that the legal questions weren't that difficult because he really didn't have any legal basis for backing out of the deal. Basically, that his litigation was frivolous. And if Musk had simply done what he was supposed to do by consummating the deal in the first place, Twitter wouldn't have to pay a success fee at all. And of course, Twitter's board was obviously pleased that Wachtell helped it close the deal at the original price. And if Twitter had renegotiated the deal so that Musk had to pay a lower share price, the shareholders would have lost billions of dollars, far more than the $90 million that they paid in the lawyer fees. And the deal, of course, closed at $44 billion, which means that the success fee wound up being about 0.2% of that eventual deal. So yeah, it's arguable that the success fee helped Twitter save a lot of money and that the board probably feels pretty good about it. And in fact, success fees are so normal with mergers and acquisitions that Musk's own law firm, Reed Collins and Sy, the lawyers handling this case for him, also charge them. But on the other hand, it's possible that Musk has a reasonable argument here. He argues that the success fee is unconscionable in part because the firm's work had already been done. Therefore, there couldn't be an enforceable contract to pay effectively an additional $90 million because, again, the work had already been done. Now, consideration in contracts refers to the benefit that each party receives in exchange for what it gives up for a contract. Gratuitous promises, aka gifts, are not enforceable. So a promise to let someone borrow your car is not enforceable. But a promise to let someone borrow your car in exchange for $100 absolutely is. And similarly, if you want to modify an existing contract, you need some new consideration, generally speaking, in order for that modification of the contract to stick. Consideration can be big or small as long as the parties mutually agree to exchange something between themselves. And right now, all the lawyers watching this video are shouting the word peppercorn at the screen. Because in law school, you learn that consideration can be something as small and insignificant as an actual peppercorn. Though these days, that is a metaphor for just something that is very small that you're giving up. Now, this could be a good argument for Musk. In the original fee agreement, Twitter agreed to pay the law firm for services that would be billed hourly. And at the last minute, Twitter agreed to pay $90 million for a success fee. And it's possible that this was improper. A fee agreement needs to spell out the services that a lawyer is performing for the client, outline the type of fees that it will charge, and give the client an idea of how much they can expect to pay. And in this case, Musk has a point that Wachtell can't change the original terms of the agreement without consideration. So how might Wachtell defend itself? Well, Joe Patrice over at Above the Law suggested that from Wachtell's point of view, this wasn't changing the terms of the original agreement per se. He suggested the firm might have been, quote, opening new talks on the comprehensive fees, involved in both litigating and advising on a deal. And under this theory, Wachtell concluded that its role in litigation was complete, as Musk said, but that they needed a new arrangement to compensate the firm for its role in advising Twitter during closing. And that's definitely a possibility, but so far we don't know if that's what Wachtell and the old Twitter owners were actually thinking. And we certainly don't know Wachtell's side of the story or the old Twitter board's side of the story. Wachtell could legitimately argue that it had to advise the company on any last-minute maneuverings by Musk, and that work, providing advice to Twitter before the deal closed, could constitute consideration. And again, getting $90 million for providing a little bit of advice seems exorbitant, but legally the consideration can be almost anything of value. And consideration will only be considered inadequate if it's really worthless. But right now we're only privy to the allegations of the complaint and the exhibit, so it's very likely that there's a lot more relevant communications here than what was attached to the complaint. Though additionally, Elon Musk says that the fee violated the ordinary course covenant that was found in the merger agreement. He suggests that Twitter employees, including the outgoing board of directors, were up to corporate sabotage. The complaint says that, quote, fully aware that nobody with an economic interest in Twitter's financial well-being was minding the store, Wachtell arranged to effectively line his pockets with funds from the company cash register while the keys were being handed over to the Musk parties. But remember, Twitter had to hire Wachtell because Elon was trying to get out of the merger agreement in the first place. And Musk complains that right before the deal closed, these stupid people met to approve the fee request despite a Musk directive to halt all payments. Quote, the closing day directive was an unequivocal statement on behalf of Twitter's residual claimants of the corporation's preference to pause outbound payments pending that day's closing so that the company's new owner could have a reasonable opportunity to review such payments. So Musk is arguing that they shouldn't have approved the fee in part because he had no intention of paying the bills that Twitter already owed. But the company didn't have to follow Elon's directive until he actually owned the company and not a moment before. So Twitter paid the fee right before the deal closed, like literally minutes before the deal closed. And Musk thinks that this timing is nefarious and that they intended to keep the payment secret. And now it's true that Twitter executives didn't have much incentive to pay the lawyers the lowest fees that they could get away with, but on the other hand, they also also weren't sure that the deal would close until the day that it actually did. So if the Twitter executives made too many crazy decisions that cost the company tons of money, they'd be screwing themselves over if Musk decided to litigate instead of closing, because they'd need to run a company that was seriously hampered by all the bad deals that they did. But there's also the fact that Musk has a long history of stiffing people he owes money to, and relying on your personal history of breaking contracts seems like a weak argument. So Musk would have been in a much better spot if he claimed that the $90 million in fees was outside the ordinary course of business and refused to move forward with the sale with that payment in place. But of course, he famously moved forward with the deal and paid $44 billion and now proudly owns a company that's worth a fraction of that. So maybe instead of hiring yet more lawyers, Elon should sit back and enjoy a delicious meal delivered straight to his door, which you can get with today's sponsor, Factor. Because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat. Eliminate the hours it would take to shop, meal prep, and cook so you can spend your day doing the things that you actually want to do. Factor meals arrive pre-prepared and ready to eat in just 2 minutes. At the same time I could even think about going to the grocery store, my Factor meal is already done. And sometimes I just want a good, healthy meal without having to cook, and it's surprisingly affordable too. Factor's team of gourmet chefs creates each meal using only ingredients with integrity to help you feel your best all day long. And they really are extremely delicious, like Green Goddess chicken and grilled steakhouse filet mignon, ready in just 2 minutes. The menus are updated weekly with 34 different options, so you can choose your favorite meals or let Factor craft your order based on your taste preferences and meal history. So give Factor a try by heading to factor75.com and use the code LegalEagle50 to get 50% off your first Factor box. Or just click on the link that's on screen or down in the description and use the code LegalEagle50 to get 50% off your first Factor box. And after that, click on this box over here for more Legal Eagle, or I'll see you in court.